joining us now for his views on this. Mr. Vinayak Chatterjee, thanks very much, sir, for being with us. Mr. Chatterjee, lots of points mentioned by the report. I'm just going to go through a couple of them. The court has said, and let me just quote what the court has said, "We must observe that public interest jurisprudence under Article 32 was expanded by this court to secure access to justice and to provide ordinary citizens with an opportunity to highlight legitimate causes. And therefore it has a particular purpose. However, petitions that lack adequate research and rely on unverified and unrelated material tend to be counterproductive." Is this what ultimately all of these allegations in this case came to? They were counterproductive because they were essentially not verified.
So, Vishnu, thanks for getting me on this subject, because I have studied the case pretty thoroughly. What you mentioned today is right, but it is one of the many moving parts. So if you allow me,
yes, please.
Maybe in 1 minute, I can just tell you the 5 broad principles that the Supreme Court judgment has brought to the fore. May I proceed? So that the viewers have the benefit of simplifying the court judgment. So the first one is that the court very clearly says that it does not want to step into a legitimate jurisdiction of a technical regulator, which in this case is SEBI. And this has come again and again, where if you remember, in the imported coal case with ultra mega power plants, the Supreme Court had sent the matter back to the power sector regulator, saying these are technical issues and the Supreme Court should not step into the jurisdiction of an independent regulator. In this case, it happens to be SEBI, unless, and it's an important point the Supreme Court makes, unless the petitioners are able to prove that it violates fundamental rights or any provisions of the Constitution. So therefore, in this case, the Supreme Court is not satisfied that that there are any issues of violation of fundamental rights or constitutional invalidities. So it does not want to step into the realm, into the jurisdiction of an independent regulator. Now, this is a very important point. The second important point it makes is that third-party reports cannot be regarded as conclusive proof. Whether they are independent reports like the OCCRP report or whether they are newspaper reports. Now, it says they can be produced as inputs, but should never be taken
Correct.
as conclusive evidence.
Yes.
That's bucket number 2. Bucket number 3 is that it does a deep dive on the regulatory structure and the, shall we say, the disclosures required in the FPI regulations,
yes,
the foreign portfolio investors. Now, it goes into great length. In simple terms, it says that the Supreme Court is satisfied that the way the current disclosure norms are structured with the latest version of the FPI rules, they see no invalidity in that, and therefore no constitutional or legal issues, and SEBI can investigate within those, and there is really no opaqueness as has been suggested. The second last bucket, the fourth bucket, is that the Supreme Court in this case does not see the necessity for transferring the case to another investigating authority. It says it is well within its right to do so, provided it is convinced that such a transfer to an independent regulatory authority like the ED or CBI is required. But in this case, it believes that SEBI has enough intellectual capital, legislative powers to investigate in its own right, and therefore will not entertain the idea of transferring to another agency. My last bucket, which is bucket 5, is really a clarification of a few other points made by the petitioners. One, you rightly said, and I'm not going to delve into detail because you've already covered it in your opening remarks, it cautions against the use of public interest litigation with unverified reports. You've
yes,
already talked about it.
yes,
Let me not say it again. It dismisses any hints about the reports emanating in the past on the Directorate of
But sir,
Revenue
let me
Intelligence.
ask you one point, because we've mentioned this. One key aspect over here, which we haven't discussed as yet, that the Supreme Court says, and I quote, "SEBI and the investigative agencies of the government shall probe into whether the loss suffered by Indian investors because of the conduct of Hindenburg Research and any other entities in taking short positions involved any infraction of the law, and if so, suitable action shall be taken." This is huge,
So
absolutely.
you've actually, I was
Someone has
coming
to
to
be
it.
accountable.
Yeah. So what you're saying is that any loss to Indian investors because of illegalities in short selling
Yes.
will continue to be investigated by SEBI. And if there are any infirmities found, then action will be taken. That's a very logical stand. And then let me just complete my other
Yes,
point
yes.
that the Directorate of Revenue Intelligence letter was completely tangential to the case. It has been settled and had done and dusted, and therefore there was no need to bring it up again. And the allegations, they were in fact said mischievous allegations of conflict of interest among members of the expert committee are unsubstantiated and rejected. That, Vishnu, is the broad theme, the five clusters, the broad theme of the Supreme Court judgment. So it sends some very, very important legal, regulatory, and constitutional messages. But over to you.
Mr. Chatterjee, one other key point I found really critical. The court said that it was necessary to strengthen the regulatory framework and protect investors and ensure the orderly functioning of the securities market, because at the end of the day, we aren't just talking about the Adani group. We are talking about millions of small investors in India who've had, in many cases, their life savings wiped out because of a report penned in the United States, which at the end of the day, so many months later, our Supreme Court said essentially doesn't apply. It's to protect investors as well. I think that's a huge signal, not just for today, but for tomorrow as well.
Yes, you're very right, Vishnu. I mean, this is a different form of aggression against a country, against small investors, where anybody can publish a report either for maligning a group or maligning a country, or out of pure economic interest that it has great pecuniary benefit in short selling because it has taken positions on short selling. So I think the court is correct in its assessment that with this learning, with this lesson, we must safeguard both our nation, our businessmen and developers, as well as the small and not so small investors. It affects everybody, not just small investors. So it is a wake-up call to see what the loopholes are and how they can be plugged.
All right, Mr. Chatterjee, we leave it over there. Thank you very much for joining us and sharing us, your views on the judgment, on the order of the Supreme Court today.